Welcome. I request Dr. S.K. Kapoor to provide us insight about concept of relevancy of facts and in particular about Section 10 of Indian Evidence Act.
As we had seen that on the first date of hearing, public prosecutor opens his case on 2 points. The charge on which he wants that accused be put up on trial and the evidence with which he plans to prove the charge. As far as the first aspect of charge is concerned, it takes us to the ingredients of the offenses. As far as the second aspect of the evidence is concerned, it takes us to that with respect to which facts law permits evidence to be led by either party. This takes us to Chapter 2 of the Indian Evidence Act. Chapter 2 of Indian Evidence Act is titled of Relevancy of Facts. Now, only with respect to the relevant facts, law permits evidence to be led. Section 5 is specific that evidence may be given of facts in issue and relevant facts. Now, facts in issue in the context of the criminal law would mean the ingredients of the offense or the defense when accused will enter upon that aspect of leading a defense for it. So the evidence which the prosecution is permitted to lead is with respect to the ingredients of offenses and relevant facts. As far as the ingredients of offense are concerned, those are naturally the central core which is to be established by the prosecution. Now, those ingredients are the facts with respect to which the evidence is to be led by the prosecution. However, the law provides that the relevant facts, the facts which will be relevant to the ingredients or issues as the word is. So evidence is to be led with respect to the facts in issue, means the ingredients which are to be proved, and the relevant facts. So the focus today of our visit is about the relevant facts. So naturally, the question will arise, which facts are accepted as relevant facts? It is here in this chapter 2 that this aspect of definition of relevant facts or which facts are accepted by Indian Evidence Act being relevant facts, and it is only with respect to those that party may be in a position to lead an evidence or party is within his rights to lead an evidence. Therefore, let us now read these sections 5 to 16 of chapter 2 as to have an insight as to what precisely it would mean. I am reading section 5. Evidence may be given of facts in issue and relevant facts. So it is the first principle that we can lead evidence with respect to the issues and the relevant facts. Evidence may be given in any suit or proceeding of the existence of or non-existence of every fact in issue and each other fact as are hereinafter declared to be relevant and of no others. So this section 5 specifically provides that evidence can be led with respect to the existence or non-existence of every fact in issue. Existence or non-existence of every fact in issue and such other facts as are hereinafter declared to be relevant. Means what is permitted hereinafter, means in this chapter, but of no other facts. means it is made exhaustive. It has been made specific that evidence can be led only with respect to the existence or non-existence of fact in issue, every fact in issue, and the facts which have been declared relevant here in this chapter. Therefore, to have proper comprehension of what is permitted under law of evidence is with respect to the issues and other facts which have been declared relevant in this chapter. Therefore, we have to be very thorough about the specific provisions, as it is only in terms of these premises, this permissibility, that we or any party can lead an evidence. Now, there is an explanation under Section 5. This section shall not enable any person to give evidence of a fact which is disentitled to prove by any provision law for the time being in force relating to civil procedures. Now, it is not with respect to the criminal procedure. With respect to the civil procedures, if there are prohibitions provided, then those facts with respect to prohibition is provided will not be permitted, even if it is a fact in issue or otherwise it is relevant. Therefore, this explanation is to be kept in mind while deciding, planning the evidence to be led in civil suits. Now see, Section 6, relevancy of facts forming part of same transaction. See, it is the first category, the first clause. Facts which, though not in issue, are so connected with the fact in issue and form part of the same transaction are relevant whether they occurred at the same time and place or at different times and places. See how big zone this is. Facts which, though not in issue, are so connected with the fact in issue as to form part of the same transaction. So the connection with the fact in issue to be of the nature that it makes it a part of the same transaction. The word transaction as such is not defined, and it is to be inferred by its ordinary natural meanings. Now, if there is fact A which is an issue and fact B which is forming same transaction with A, if fact A and fact B are forming part of the same transaction, but fact A is an issue, then fact B will become relevant. And in Section 5, it is provided that evidence can be led with respect to the relevant facts hereinafter declared, hereinafter provided for. Section 6, as such, is permissible zone within Section 5. And Section 6 provides that facts which form part of the same transaction are so connected, that means the connection between fact A in issue with fact B which is not an issue, if is of such generic, is of such specific, that A and B form the same transaction, then B will become relevant. And once it is relevant, and under Section 5, evidence can be led with respect to fact B. Now see, the Section 7. The Section 7 provides facts which are the occasion, cause, or effect of the fact in issue. Section 6 is taking care of the connected facts which form the same transaction. However, Section 7 goes to a different premises, to a different zone, different category of the situations. Facts which are the occasion, means if fact B arises out of fact A, or is the cause, if fact B is cause of fact A, or if fact B is effect of cause A, immediate or otherwise, of relevant facts or facts in issue, or which constitute the state of things under which they happened, or which afforded an opportunity for their occurrence or transaction, are relevant. See, this is a very, very big zone. This zone deserves to be appreciated. One be through this text number of times, as it is so worded, it is so legislated, as that it has taken into projections of practically every realistic situation which is going to be the necessity of the adjudication to reach a decision. Let us reread this section. Facts which are number one, occasion, number two, cause, number three, effect. This occasion, cause, and effect may be immediate or otherwise. So it is not necessary that this occasion, cause, or effect shall be immediate. It may be remote or otherwise, comma, of what? Of relevant facts. So the facts which are occasion, cause, or effect of the relevant facts, or facts in issue. So facts in issue and the relevant facts, and the facts which are occasion, cause, or effect of the same, or which constitute the state of things under which they happen. Now see the word used, the state of things. Let me read again. Facts which are the occasion, cause, or effect, immediate or otherwise, of relevant facts or facts in issue. So there are two branches, number of facts in issue, number two are the relevant facts. Now facts in issue will come from the ingredients of the offenses, and the relevant facts will come from the permissibility in chapter 2 from section 6 onwards. Therefore, if we have to bring our case for admissibility of an evidence, then we have to bring that piece of evidence which we want to lead should come either as fact in issue, means as an ingredient of offense, or it is to be the relevant fact. Now the relevant facts are section 6, section 7 onwards. So section 7 itself is providing the relevancy permissibility. Therefore, section 7 is to be reread as it is to be read with respect to the facts which it permits to be relevant, to be again applied the same test and yardstick. Now, it is a double layer, it is a double fold, it is a core within a core. Therefore, the facts which will become relevant under section 7, the same will further permit those facts which will be occasion, cause, or effect of such facts, and then they again will become the relevant facts. So it will become a permissibility, and this occasion, cause, or effect may be immediate or otherwise. So it is not necessary that the facts which we want to bring under section 7 shall be the immediate cause, effect, or the occasion. They may be otherwise as well, with a distant point of time, or with different situations, are in connection with many other facts or situations and circumstances. Therefore, the permissibility zone of Section 7 is a very big zone which has a layer within the layer, and as such, let us rephrase it and let us chase it phrase by phrase, stage by stage. I am reading again. Facts which are the occasion, cause or effect, immediate or otherwise, of relevant facts or facts in issue, or the third situation, which constitute the state of things. Now see, we have the facts in issue, we have the relevant facts, and now here is a third species, third generic. It is which constitute the state of things under which they happen, or which afforded an opportunity for their occurrence or transaction as they are relevant. Let us reread it. Facts which are occasion, cause or effect, immediate or otherwise, of number one, relevant facts or facts in issue, or which constitute the state of things under which they happened, which afforded an opportunity for their occurrence or transaction or relevant. Now, let us proceed a step ahead. Now it is section 8. It is another generic. It is another reservoir. It is another box. It is another room. It is another universe, which is also having legislative stamp of relevancy. See, motive, preparation, and previous or subsequent conduct. Crime is having a point of time of its occurrence. Then there would be prior movements and there will be subsequent movements as well. If say crime has happened at point of time t, then movements prior to point of time t and movements subsequent to point of t as well, or the human conduct situations which help reach at the decision. As mensa rea we know is the basic ingredient, basic constituent, basic feature, basic value. And with respect to it, the mental states, which is a continuous phenomenon, and human conduct, which also is a continuing phenomenon. Therefore, as far as the motive, preparations, and conduct is concerned, there are three words: motive, preparations, and conduct. Same may be previous or subsequent to the happening of the crime or event. Now let me read it. A fact is relevant which shows or constitutes a motive or preparation for any fact in issue or relevant fact. See, any fact is relevant which shows or constitutes what? A motive or preparation of any fact in issue or relevant fact. Then further, conduct of any party or of any agent to any party. The conduct of any party or of any agent to any party, to any suit or proceeding in reference to such suit or proceeding, or in reference to any fact and issue therein, or relevant thereto, and the conduct of any person, an offense against whom is the subject of any proceedings, is relevant if such conduct influences or is influenced by any fact in issue, a relevant fact, and whether it was previous or subsequent thereto. See, this group of situation, this set of situations, are also a universe in itself. As we are dealing with the human beings on trial, as the life and liberty of human beings is on trial. Therefore, human conduct and human motivations, human efforts and preparations, human conduct and act are being legislated for their exhaustive coverage. And it is in this context, Section 8 be read as a code in itself, as a universe in itself, like Section 7, which is a code in itself, which is a reservoir in itself. It is a full universe of that domain. That universal domain of Section 7 is a distinct universe, and Section 8 again is a distinct universe which has been conceived, which has been visualized, and which has been given the sanction, and it has a legislative seal. And so this is to play its effective role to reach at the justice. This Section 8 is also having an explanation. There are two explanations. Firstly, the word conduct in this section does not include. Now, see what conduct means. The word conduct in this section does not include statements under those statements accompany and explain acts other than statements, but this explanation is not to affect the relevancy of statements under any other section of this act. When we will proceed further, we will see that Section 17 onwards of this chapter are relating the admissions and statements. Therefore, it has been made specific here itself that the definition of conduct being given here is only meant for and restricted up till the interpretation of Section 8 only. And the same is not to influence or affect the other provisions. And explanation 2 says, when the conduct of any person is relevant, any statement made to him or in his presence and hearing which affects such conduct is relevant. Now let us proceed further. Section 9 is taking us to the situations, facts necessary to explain or introduce a fact in issue or relevant fact, or which support or abut an inference suggested by the fact in issue or relevant fact, or which establish the identity of anything or person whose identity is relevant, or fix the time or place at which any fact in issue or relevant fact happened, or which shows the relation of the parties to whom any such factor was transacted, are relevant in so far as they are necessary for that purpose. Means, if interpretation is an issue, if the interconnections is an issue, then those facts are taken to be necessary. The facts necessary to explain or introduce relevant facts. So it in a way is an interpretive clause. It gives the rule of interpretation, and to facilitate it, the same has been legislated to give it the relevancy. Once these necessary explanations and these introductory situations are given the status of relevance, then naturally these are the situations of permissibility of leading and evidence. And it is in this background that when we go to Section 10 of Indian Evidence Act, it is with respect to the conspiracies. And it is with respect to the things said or done by conspirator in reference to common design. We know design is a mental state. As it is a mental state, therefore, we have to reach it by some external, physical, mundane, existential, observable by senses, etc., are to be availed. And therefore, Section 10 says, where there is reasonable ground to believe that two or more persons have conspired together to commit an offense or an actionable wrong, anything said, done, or written by any one of such persons in reference to their common intention after the time when such intention was first entertained by any one of them is irrelevant. Means when there is a conspiracy, means more than one persons are there, then conduct of each one of them becomes relevant for others as well, because this relevancy in fact is to prove the common agreement, common intention, common design on their part. Therefore, conduct of any one of them is made relevant and as such is stretched for to be applied to each one of us. This way we have seen that the Indian Evidence Act, by introducing the concept of relevancy, has really facilitated adjudications to have a conclusive decision whether or not charge stands proved. Therefore, at the initial stage itself, we have to scrutinize all the pieces of evidence being put forward or being suggested by the prosecutor, and we have to point out then and there which part as such will be lawfully permissible or not. Thank you very much.
Sir, can you hear me?
Yes, please.
Sir, my only request was like we are discussing section, these are very essential. I think we should cover illustration also given in the Indian Evidence Act, sir. That will make us even more focused and clear. That will help us in getting even better understanding, sir.
Certainly. What I am trying at present is, at the first phase, is to let us have a general view of this, the general spectrum, first visit to these provisions. And then when we will have a second phase of reading it, then we'll take it clause by clause, section by section, then by with the authorities as well. Naturally, the illustrations are very helpful. In fact, once this is the, when we go through the history of legislation of the things, then this Indian Evidence Act is cited as that illustrations, though not part of the text, but still are nevertheless equal to the status of the text itself. Really wonderful. Suggestion is nice. We have to be through. We will be through it when we will be taking up only section by section. Still, I am taking up a general view, and in the next phase, within few days, we will take up this aspect. Then it would be really nice. Thank you. Wonderful.